Ready, start. Reliance is also placed on Sajjan Kumar versus CBI to contend that a prima facie opinion cannot be formed on a mere suspicion as distinguished from a grave suspicion. Full stop. Learned senior counsel appearing for the complainant slash respondent at the outset referred to section 20 of the act to point out that there is a statutory presumption against the accused, and in the present case there is a demand of bribe made by the Minister of State as evident from the statements recorded in the investigation report. Full stop. Neeraj Datta was quoted to urge that in the absence of direct oral or documentary evidence, the court could draw inference from the evidence available, including circumstantial, to bring home the guilt of the accused. Full stop. The policy deviation is a clear pointer to the avaricious intent of the accused to illegally profit, at the expense of the state, which demonstrably suffered huge losses. Full stop. The learned senior counsel would take us to the statements recorded by the investigation team as available in the voluminous report to argue that there has been allegation of demands made, and at this stage there cannot be an abrupt closure of the case under section 482 of the CRPC. Full stop. The findings of the High Court at the earlier instance, that there is a prima facie case against the accused still has relevance and cannot be easily upset. Full stop. The Sessions Court and the High Court have clearly found that there is prima facie case against the accused from the available materials in the investigation report. Full stop. It was looking at the investigation report that the court has entered on the prima facie finding to reject the prayer for discharge. Full stop. Reliance is also placed on the order of the High Court, in a writ petition moved by the complainant, where the illegal grants were cancelled and the state was directed to proceed in a proper tendering process. Full stop. The clear policy of the government mandated tendering insofar as distribution of state projects which could not have been deviated from by the minister or the department. Full stop. It was under the minister's order that the department proceeded to make the grants without resorting to a tender process. Full stop. Invocation of section 482 at this stage would send a wrong message to the society, concludes the learned senior counsel. Full stop. Learned counsel appearing for the state refuses to take sides and points out that while there is nothing found clearly as to the acceptance of bribe, by the investigation team, there is a statement recorded of a demand made by the first accused. Full stop. The investigation report discloses that there was a meeting convened, of the zonal officers of the fisheries department in the chambers of the first accused, in which the decision was taken to allocate water bodies, which decision was approved by the second accused. Full stop. The entire controversy arose by reason of the grant of fishing rights in the reservoirs owned by the state. Full stop. The second accused at that time was the Minister of Fisheries in the government of Gujarat, when the grant was made. Full stop. The complainant filed a special civil application number 9958 of 2009, in which the High Court quashed the fishing grants enabling fishing rights in the individual reservoirs and directed a tender process to be followed. Full stop. Pursuant to the orders of the High Court of Gujarat, a tender process was initiated, and the complainant had also specifically pointed out the vast difference in the bids made pursuant to the tender process, which was, far more than that for which the grants were made illegally by the minister and the departmental officers. Full stop. According to the respondent slash complainant, this raises a presumption that there was an attempt to obtain undue advantage as a motive or reward under section 7, for performing a public duty improperly, and dishonestly, full stop. The learned senior counsel appearing for the appellant had clearly pointed out that at this stage no presumption can be raised under section 20, especially when the provisions speaks of proof offered at a trial semicolon that the public servant accused of an offense has demanded accepted or obtained or attempted to obtain for himself or for any other person any undue advantage from any person, full stop. Only on such proof offered the presumption can be raised that the demand or receipt of illegal gratification was as a motive or reward such as is mentioned in section 7 semicolon without consideration or inadequate consideration, full stop. In the present case, from the materials produced before the special court, there is nothing indicating even an allegation of demand of bribe by the second accused, which would clearly indicate that there is no question of any proof being offered at the trial, full stop.